Haaland, Secretary of the Interior, et al. V. Brackeen et al. On writs of certiorari to the United States Court of Appeals for the Fifth Circuit. June 15, 2023. Justice Thomas dissenting. These cases concern the federal government's attempt to regulate child welfare proceedings in state courts. That should raise alarm bells. Our federal government is acknowledged by all to be one of enumerated powers, having only those powers that the Constitution confers expressly or by necessary implication. McCulloch v. Maryland, 1819. All other powers like family or criminal law generally remain with the states. The federal government thus lacks a general police power to regulate state family law. However, in the Indian Child Welfare Act ICWA, Congress ignored the normal limits on the federal government's power and prescribed rules to regulate state child custody proceedings in one circumstance, when the child involved happens to be an Indian. As the majority acknowledges, ICWA often overrides state family law by dictating that state courts place Indian children with Indian caretakers, even if doing so is not in the child's best interest. It imposes heightened standards before removing Indian children from unsafe environments, and it allows tribes to unilaterally enroll Indian children and then intervene in their custody proceedings. In the normal course, we would say that the federal government has no authority to enact any of this. Yet the majority declines to hold that ICWA is unconstitutional, reasoning that the petitioners before us have not borne their burden of showing how Congress exceeded its powers. This gets things backwards. When Congress has so clearly intruded upon a long-standing domain of exclusive state powers, we must ask not whether a constitutional provision prohibits that intrusion, but whether a constitutional provision authorizes it. The majority and respondents gesture to a smorgasbord of constitutional hooks to support ICWA. Not one of them works. First, the Indian Commerce Clause is about commerce, not children. See Adoptive Couple v. Baby Girl 2013 Thomas concurring. Second, the treaty clause does no work because ICWA is not based on any treaty. Third, the foreign affairs powers, what the majority terms structural principles inherent in the federal government, have no application to regulating the domestic child custody proceedings of U.S. citizens living within the jurisdiction of states. I would go no further, but as the majority notes, the court's precedents have repeatedly referred to a plenary power that Congress possesses over Indian affairs, as well as a general trust relationship with the Indians. I have searched in vain for any constitutional basis for such a plenary power, which appears to have been born of loose language and judicial ipse dixit. And even taking the court's precedents as given, there is no reason to extend this plenary power to the situation before us today. Regulating state court child custody proceedings of U.S. citizens, who may never have even set foot on Indian lands, merely because the child involved happens to be an Indian. Thomas Dissent, Section 1. State courts usually apply state law when resolving child custody issues. This would normally be true for most Indians, too. Today, Indians are citizens of the United States. The vast majority of them do not live on any reservation or Indian lands, but live as most citizens on lands that are wholly within a state's jurisdiction. See Chapter 233, 43 Statute 253, Department of Health and Human Services, Office of Minority Health Profile. American Indian Alaska Native February 24, 2023, 87% live off Indian lands. Thus, one might expect that when a child custody issue regarding an Indian child arises in a state court, that court would apply the same laws that it would for any other citizen. But ICWA displaces the normal state laws governing child custody when it comes to only one group of citizens, Indian children. ICWA defines Indian child capaciously. It includes not only children who are members of an Indian tribe, but also those children who are merely eligible for membership in a tribe and are the biological child of a tribal member. See 25 U.S.C. Section 19034. If the child resides on Indian tribal lands, then the Indian Tribal Court has jurisdiction. Section 1911A. But if the child resides within a state, ICWA requires state courts to transfer any proceedings to a tribal court, absent good cause to the contrary, upon petition by the child's parent, custodian, or tribe. Section 1911B. Even when the state court retains the proceedings, ICWA replaces state law with a strict set of federal rules. For example, if the state fears that a child is suffering physical or sexual abuse, it must clear a set of hurdles before placing the child in foster care or terminating the parent's rights. Sections 1912A through E. If the parent wishes to voluntarily relinquish his or her rights and facilitate an adoption, the child's tribe has a right to intervene at any point and to collaterally attack the court's decree. Sections 1911C, 1914. Moreover, it appears that tribes can enroll children unilaterally, without the parent's consent. Accordingly, even if the biological parents, the child, the adoptive parents, and the court all agree on what is best for the child, the tribe can intervene at the 11th hour, without any consent from the parents or child, and block the proceedings. In fact, that is exactly what happened here. The children were unilaterally designated as tribal members by tribes, which then sought to block adoptions that everyone else thought were best for the children involved. And even though some of those adoptions have now been finalized, it appears that the tribes can collaterally attack them for an indefinite period of time. Section 1914. Besides these procedural hurdles, ICWA dictates the preferences a court must adhere to when deciding where to place the child. In the typical case, the primary consideration would be the best interests of that child. Example given, Texas Family Code Annotated Section 153.2 2014, American Law Institute, Principles of the Law of Family Dissolution Section 2.2 2002, Friederwitzer v. Friederwitzer 1982, Carner v. McMahon 1994. That makes sense. As the majority notes, these children are some of the most vulnerable among us, and their interests should be a court's primary concern. But ICWA displaces that standard with its own hierarchy of preferences, requiring a court to prefer any placements with one, a member of the child's extended family, two, other members of the child's tribe, and three, other Indian families of any tribe, anywhere in the country. Section 1915A. Similar rules govern foster care placements. Section 1915B. As the majority notes, these preferences collectively ensure that any Indian from any tribe in the country outranks all non-Indians for adopting and fostering those whom ICWA deems to be Indian children. Again, these detailed rules govern the child custody proceedings of U.S. citizens in state courts only because the child is also either a member of an Indian tribe or merely eligible for membership in a tribe. The child or parents need never have set foot on Indian lands or have any desire to affiliate themselves with a tribe. The child and his or her biological parents and relatives can all support an adoption, yet ICWA may stand in the way. Normally, we would say that the federal government plainly lacks the authority to enact a law like this. The only question is thus whether Congress has some additional authority that allows it to regulate the adoption process for involved happens to be an Indian. To answer that question, I turn first to the text and original meaning of the Constitution. Thomas Dissent, Section 2. To explain the original understanding of the Constitution's enumerated powers with regard to Indians, I start with our nation's founding-era dealings with Indian tribes. Those early interactions underscore that the Constitution conferred specific, enumerated powers on the federal government, which aimed at specific problems that the nation faced under the Articles of Confederation. The new federal government's actions with respect to Indian tribes are easily explained by those enumerated powers. Meanwhile, the states continue to enjoy substantial authority with regard to tribes. At each turn, history and constitutional text, thus point to a set of enumerated powers that can be applied to Indian tribes, not some sort of amorphous, unlimited power that can be applied to displace all state laws when it comes to Indians. Thomas Dissent, Section 2A. Before the Revolution, most of the 13 colonies adopted their own regulations governing Indian trade. See Adoptive Couple 2013, Thomas concurring, R. Natelson, The Original Understanding of the Indian Commerce Clause, 2007, Natelson Collecting Laws. These regulations were necessary because colonial traders abused their Indian trading partners, often provoking violent Indian retaliation. See Adoptive Couple 2013, F. Prucha, The Great Father 18 to 21 1984 Prucha. Most colonial governments thus imposed licensing systems of some form both to protect Indians and to maintain trading relationships with them. However, the colonial laws were not uniform, leading to rivalries between the colonies, corruption, fraud, and other abuses by traders. Then, once the nation had achieved independence, it faced innumerable difficulties, from finding ways to uphold its treaties with foreign nations to economic upheaval at home. J. Marshall, The Life of George Washington 313 to 316 R. Faulkner and P. Carey's 2000. Peace with the Indians, rather than conflicts sparked by unscrupulous traders, was imperative. Prucha 46. The Articles of Confederation aimed to meet that need in part by giving Congress the sole and exclusive right and power of regulating the trade and managing all affairs with the Indians. Article 9, Clause 4. However, that broad power came with two limitations. First, the Indians could not be members of any of the states. And second, the legislative right of any state within its own limits could not be infringed or violated. In part because of those limitations, the Article's solution proved to be less than ideal. As James Madison would later write, the two limits were obscure and contradictory. The new nation had not yet settled on which Indians were members of a state or which state legislative rights could not be infringed. The Federalist No. 42, see Rossiter 1961. More broadly, the Confederation Congress lacked any robust authority to enforce congressional laws or treaties in this or any other domain. For example, it had no power to make laws supreme over state law. There was no executive power independent of the states, and state officers were not bound by oath to support the Articles. Under the Articles, Congress entered treaties with various tribes and sought to maintain a mostly peaceful relationship with the Indians, but its authority was undermined at every turn. See Prucha 44 to 50. Again and again, Congress entered treaties with Indians that established boundary lines and lands set apart for the Indians. And again, frontier settlers encroached on Indian territory and committed acts that violated those treaties. F. Cohen, Handbook of Federal Indian Law Section 1.023 2012 Cohen. Such violations were taken seriously. As offenses against the laws of nations, they provoked the Indians and provided just causes of war. The Federalist No. 3 J.J. See also 2 E. DeVattle, The Law of Nations sections 71 to 76, pages 161 to 163 J. Chitty 1876. Yet the Confederation Congress was almost powerless to stop these abuses. After a committee noted confusion about the extent of congressional power over Indian affairs in 1787, Congress had to ask the states for their cooperation in curbing the abuses that their own citizens were perpetrating. Prucha 48 to 49. The weakness of Congress meant, however, that federal attempts to check state intrusions were often ignored. Cohen Section 1.023. The result was that, by the time of the Constitutional Convention, the young nation stood on the brink of Indian warfare on several fronts. Such a war, feared some founders, could be destructive to the fledgling republic. C. G. Ablavsky, The Savage Constitution, 2014. The Constitution addressed those problems in several ways. First and most plainly, the Constitution made all federal treaties and laws the supreme law of the land, notwithstanding the laws of any state. Article 6. It empowered Congress not only to declare war, but also to raise and support armies, provide and maintain a navy, and provide for calling forth the militia to execute the laws of the Union. Article 1, Section 8. It enabled Congress to define and punish offenses against the law of nations, and it granted Congress the authority to make all laws which shall be necessary and proper for carrying out any of those powers. The Constitution also provided one power specific to Indian tribes, the power to regulate commerce with the Indian tribes. Section 8, Clause 3. That power, however, came very late in the drafting process and was narrower than initially proposed. C. L. Toller, The Missing Indian Affairs Clause, 2021 Toller. At two separate points, James Madison and John Ruddle proposed a power to regulate affairs with the Indians, a provision that would have mirrored the Articles. Neither proposal received much debate, and both were rejected. Instead, the convention opted to include Indian tribes in a provision that had initially been drafted to include only power to regulate commerce with foreign nations, and among the several states. The convention thus expanded the Commerce Clause to the form we know today, empowering Congress to regulate commerce with foreign nations, and among the several states, and with the Indian tribes. On top of those powers, one more warrants note. As I have written previously, the Constitution vests the President with certain foreign affairs powers, including the executive power, which includes a residual authority over war, peace, and foreign interactions. See Article 2. Zivotofsky v. Carey 2015. Thomas concurring in judgment in part and dissenting in part. United States v. Curtis, Wright Export Corp. 1936. From the start, presidents have exercised foreign affairs powers, not specifically enumerated, on matters ranging from maintaining the peace and issuing passports to communicating with foreign governments and repelling sudden attacks on the nation. S. Prakash, Imperial from the Beginning 2015. In his Neutrality Proclamation, for example, President Washington declared that the United States would remain strictly neutral in the then ongoing war between England and France. See a proclamation April 22, 1793, reprinted in One American State Papers 140 W. Laurie and M. Clark 1833. Congress supported his proclamation by imposing criminal penalties on anyone who, among other things, went beyond the limits or jurisdiction of the United States with intent to be enlisted or entered in the service of any foreign prince or state. Section 2, 1 Statute 383. While this court has at times debated whether those residual foreign affairs powers are located in the executive exclusively or the federal government more broadly, see Zivotofsky v. Carey 2015. It has long recognized the powers as arising from our constitutional framework and residing at the federal level. See example given, Curtis Wright 1936. Thomas Dissent, Section 2b. After the Constitution's ratification, the new federal government exercised its enumerated powers with regard to Indian tribes. To start, the government embarked on an era of treaty-making with Indian tribes. See Cohen Section 1.031. That treaty-focused policy reflected the Washington administration's view that Indian tribes were best dealt with as mostly foreign nations, with an eye towards peace lest frontier conflicts continue to plague the new nation. See letter from H. Knox to G. Washington, July 7, 1789, reprinted in 3 papers of George Washington 138 W. Abbott 1989. See also Toller. Many early treaties thus were treaties of peace and friendship, often providing for the restoration or exchange of prisoners, or including mutual assistance pacts. Cohen Section 1.031. Others dealt with passports and commercial affairs. And many attested to the tribe's status as dependent nations, with the United States sometimes promising to protect the tribe. Unlike the Confederation Congress, the new federal government was no longer powerless to maintain and enforce its treaties. Exercising its new military powers, the first Congress established a Department of War and vested the department with authority over Indian affairs. See Section 1, 1 Statute 50. War Secretary Henry Knox then called for, and obtained, a line of garrisons in the Indian country in order to enforce the treaties and maintain the peace of the frontier. F. Prussia, American Indian Policy in the Formative Years 1962, Prussia, American Indian Policy. Those garrisons remained for years, working to prevent American settlers from illegally entering Indian country or otherwise stirring up conflicts. Meanwhile, President Washington exercised his diplomatic authority to maintain peace on the frontier. For example, when Pennsylvania settlers killed 2 members of the Seneca Nation, Washington appointed a federal agent to meet with the Seneca and give the strongest assurances of the friendship of the United States towards that tribe, and to make pecuniary satisfaction. Letter to T. Mifflin, September 4, 1790, reprinted in 6 papers of George Washington 396 D. Tuhig ed. 1996. And in line with his executive authority to regulate all intercourse with foreign powers, see 4 J. Eliot, Debates on the Constitution 126 to 127 1863, Washington instructed Pennsylvania's governor to refer the Seneca to the executive of the United States, as possessing the only authority of regulating an intercourse with them and redressing their grievances. Letter to T. Mifflin. In Papers of George Washington 396. Congress too did its part, enacting a series of acts to regulate trade and intercourse with the Indian tribes and to preserve peace on the frontiers. See example given, 1 Statute 469, 2 Statute 139, 1 Statute 137. Those trade and intercourse acts underscored the federal government's new powers and worked to establish a policy of peace and trade with Indian tribes. For example, the acts threatened criminal penalties on any U.S. citizen who entered Indian lands and their committed crimes against Indians. See also Prussia, American Indian Policy, 188 to 193. Though opponents of those provisions contended that they were unnecessary because state laws and some treaties already provided for criminal punishment, proponents explained that the provisions were needed for those who went out of the limits of any of the states and committed crimes that may not have been covered by a particular treaty. See 3 Annals of Congress 751 1792. Thus, as with the border garrisons, these provisions were meant as an answer to the charge that the United States did not respect its treaties with Indian tribes, Prussia 92, while also securing peace with the Indian tribes on the frontier, 3 Annals of Congress 751. In that respect, they were much like the criminal penalties that Congress levied on those who went abroad and enlisted with England or France, and thereby threatened the United States' peace with those nations. See 1 Statute 383. The Trade and Intercourse Acts further hammered out the nation's diplomatic and territorial stance with respect to the Indian tribes. For example, reflecting the federal government's powers over commerce, territories, and foreign affairs, the acts forbade U.S. citizens from purchasing, surveying, or settling on Indian lands. One of the acts, enacted in 1796, then drew a boundary line with Indian tribes and required citizens to have passports when entering Indian lands. If an Indian came over the boundary line and committed a crime against a U.S. citizen, the acts authorized the president to demand satisfaction from the tribe, while specifying that the Indian could be arrested within the limits of any state. See example given, Section 14, 472 to 473. Then, to prevent the tribes from allying themselves with European powers, Congress forbade people from conveying messages to Indian tribes from foreign states. 2 Statute 6. Congress also, of course, regulated trade with the Indian tribes. For example, the acts continued the colonial practice of requiring licenses to trade with Indians and threatened penalties on anyone who sold or purchased goods from Indians without a license. See example given, 1 Statute 329 to 330. To facilitate trade, Congress also established a series of trading houses on the frontiers, appropriating federal funds to set up the houses and purchase goods from Indians. And to promote civilization and secure the tribe's friendship, Congress appropriated funds for the president to furnish gifts to the Indians. See example given, Section 13, 1 Statute 472. To be sure, these measures were not entirely successful, and the federal government's policy was not always one of peace. American frontiersmen continued to push into Indian lands, and the military garrisons sometimes could not stem the tide. See Prucha 62-63, 112. The Indians, often supported by the British, engaged in intermittent raids and attacks against American settlers, and the federal government and several confederated tribes fought a significant war in the Northwest Territories. J.U. Crisis and Command 75-79, 2011. M. Fletcher and W. Singal, Indian Children and the Federal Tribal Trust Relationship, 2017. Fletcher and Singal. Additionally, the federal government often played tribes against each other to obtain land concessions by treaty, leading many tribes, again goaded by the British, to take up arms against the United States in the War of 1812. See Cohen Section 1.033 at 39-41. In the aftermath of that conflict, Presidents Monroe and John Quincy Adams generally pursued a policy of assimilation or removing Indians west with their consent. Prucha, American Indian Policy 226-233. That policy then gave way to a more forceful policy of removing Indians west, particularly during the administration of President Andrew Jackson. Cohen Section 1.034 at 41-51, Prucha 193-195, 239-240. But at least until the War of 1812, and in large part in the years after it, founding-era presidents' primary goals in this area were to achieve peace with the Indians, sustain trade with them, and obtain Indian lands through treaties. By establishing a peaceful and trade-oriented relationship with the Indians, the new country further hoped to exclude British Canada and other European powers that might seek alliances with the Indian tribes. See Cohen Section 1.033 at 37-38, 2 Statute 6. During that time, the federal government's relationship with the Indians thus remained, as it did for nearly the first 100 years of our nation, more an aspect of military and foreign policy than simple domestic law. See United States v. Lara 2004. Thomas Dissent, Section 2C. Notably, neither President Washington nor the first Congresses were particularly concerned with the remnants of tribes that had been absorbed by the states and had come under their direction and control. Prucha 92. The first Trade and Intercourse Acts specifically provided that nothing in this act shall be construed to prevent any trade or intercourse with Indians living on lands surrounded by settlements of the citizens of the United States, and being within the jurisdiction of any of the individual states. Section 13, 1 Statute 331, Section 19. And the Constitution's apportionment clause provided that representatives would be apportioned by the population of each state, excluding Indians not taxed, implying that there were Indians who paid taxes and were incorporated into the bodies politic of the states. Article I, Section 2, Clause 3. The states accordingly enacted numerous laws to regulate Indians within their territorial boundaries, as well as those Indians' interactions with the state's citizens. See example given, D. Rosen, American Indians and State Law 2007 Rosen. For example, New York passed laws forbidding its citizens from suing to enforce contracts with Indians who lived on Indian lands, and Virginia regulated the sale of land held by Indians. See Laws of the Colonial and State Governments relating to Indians and Indian affairs from 1633 to 1831, 1832. Massachusetts authorized its governor to appoint guardians to oversee Indians and their property, while Ohio and Indiana forbade the sale of liquor to Indians. On the whole, states also generally applied both their civil and criminal laws to Indians, with many extending their criminal laws to all Indians anywhere in the state, including, sometimes, on Indian reservations within the state. See Rosen 53. See also example given, Goodell v. Jackson x Dem Smith 1823. State v. Dockstader 1879 collecting cases. To be sure, some of these laws may have conflicted with valid federal treaties or statutes on point, and courts at the time often did not precisely demarcate the constitutional boundaries between state and federal authority. Rosen 55-56. But when opponents of the Trade and Intercourse Act's criminal provisions complained that state laws would take care of criminal offenses, the provision's proponents did not reply that state laws were disabled on this point. They instead noted that citizens might go beyond the limits of states and commit crimes. See 3 Annals of Congress 751. And notably, Congress' early statutes did not purport to regulate Indians either on or off Indian lands. They instead regulated and penalized only U.S. citizens who were trading with Indians or committing acts on Indian lands that threatened the peace with the tribes. Those statutory lines reflected the early dynamic of federal-Indian relations, with Indian affairs counting as both a matter of quasi-foreign affairs and of state jurisdiction. For example, the early Trade and Intercourse Acts only demanded satisfaction from Indian tribes if an Indian went onto a state's land and committed a crime. Example given, 1 Statute 472-473. Under that regime, the federal government asserted no authority over the acts of Indians who lived on tribal lands, much less over Indians who lived off tribal lands and within a state's sole jurisdiction. That general jurisdictional line held until 1817, when Congress first enacted a statute to impose penalties on anyone who committed a crime against a U.S. citizen while on Indian lands. See 3 Statute 383. But Justice McLean, Riding Circuit, held that statute unconstitutional in 1834, at least as it applied to Indian lands located within the territorial limits of a state. See United States v. Bailey, 1883. As Justice McLean explained, that the federal government is one of limited powers, is a principle so obvious as not to admit of controversy. Yet the Indian lands at issue were not located within a federal territory, and there had not been any cession of jurisdiction by the state of Tennessee. Nor was the criminal statute in any way related to commerce with the Indian tribes. Indeed, Justice McLean asked, if Congress could enact this statute, why may not Congress legislate on crimes for the states generally? He concluded that Congress transcended their constitutional powers in asserting a general criminal jurisdiction over tribal lands within the limits of a state. And given the limited nature of the federal government's authority, state laws thus played a significant role in regulating Indians within the territorial limits of states. Thomas Dissent, Section 3. The Constitution's text and the foregoing history point to a set of discrete, enumerated powers applicable to Indian tribes, just as in any other context. Although our cases have at times suggested a broader power with respect to Indians, there is no evidence for such a free-floating authority anywhere in the text or original understanding of the Constitution. To the contrary, all of the government's early acts with respect to Indians are easily explicable under our normal understanding of the Constitution's enumerated powers. For example, the Treaty Clause supported the federal government's treaties with Indians, and the Property Clause supported the gifts allocated to Indians. The powers to regulate territories and foreign affairs supported the regulation of passports and penalties for criminal acts on Indian lands. The various war-related powers supported military campaigns against Indian tribes. And the Commerce Clause supported the regulation of trade with Indian tribes. Moreover, the founders deliberately chose to enumerate one power specific to Indian tribes, the power to regulate commerce with tribes, Because the Constitution contains one Indian-specific power, there is simply no reason to think that there is some sort of free-floating, unlimited power over all things related to Indians. That is common sense. Expressio unius est exclusio alterius. And that is particularly true here, because the founders adopted the Indian Commerce Clause while rejecting an arguably broader authority over Indian affairs. See Adoptive Couple 2013. Accordingly, here as elsewhere, the federal government can exercise only its constitutionally enumerated powers. Because each of those powers contains its own inherent limits, none of them can support an additional unbounded power over all Indian-related matters. Indeed, the history of the plenary power doctrine in Indian law shows that, from its inception, it has been a power in search of a constitutional basis, and the majority opinion shows that this is still the case. Thomas Dissent, Section 3A. As the majority notes, some of the candidates that this court has suggested as the source of the plenary power are the Treaty Clause, the Commerce Clause, and principles inherent in the Constitution's structure. Lara 2004. But each of those powers has clear, inherent limits, and not one suggests any sort of unlimited power over Indian affairs, much less a power to regulate U.S. citizens outside of Indian lands merely because those individuals happen to be Indians. I will discuss each in turn. Thomas Dissent, Section 3A1. First and most obviously, the Treaty Clause confers only the power to make treaties. The Supremacy Clause then makes those treaties the supreme law of the land. Article 2, Section 2, Clause 2, Article 6. Even under our most expansive Treaty Clause precedents, this power is still limited to actual treaties. See Bond v. United States 2014, Thomas concurring in judgment. The treaty power supports treaties only on matters of international intercourse. Missouri v. Haaland 1920. It does not confer a free-floating power over matters that might involve a party to a treaty. Thomas Dissent, Section 3A2. Second, the Commerce Clause confers only the authority to regulate commerce with the Indian tribes. Article 1, Section 8, Clause 3 emphasis added. At the time the original Constitution was ratified, commerce consisted of selling, buying, and bartering, as well as transporting for these purposes. United States v. Lopez 1995, Thomas concurring. See also 1S. Johnson, A Dictionary of the English Language 361 1773 reprint 1978 defining commerce as intercourse, exchange of one thing for another, interchange of anything, trade, traffic. And even under our most expansive Commerce Clause precedents, the clause permits Congress to regulate only economic activity like producing materials that will be sold or exchanged as a matter of commerce. See Lopez 1995, Gonzalez v. Raich 2005. The majority, however, suggests that the Commerce Clause could have a broader application with respect to Indian tribes than for commerce between states or with foreign nations. That makes little textual sense. The Commerce Clause confers the power to regulate a single object, commerce, that is then cabined by three prepositional phrases, with foreign nations and among the several states and with the Indian tribes. Article 1, Section 8, Clause 3. Accordingly, one would naturally read the term commerce as having the same meaning with respect to each type of commerce the clause proceeds to identify. See Gibbons v. Ogden 1824. I would think that is how we would read, for example, the President's appointment power with respect to ambassadors, judges of the Supreme Court, and all other officers of the United States. Article 2, Section 2, Clause 2. There is no textual reason why the Commerce Clause would be different. Nor have the parties or the numerous amici presented any evidence that the founders thought that the term commerce in the Commerce Clause meant different things for Indian tribes than it did for commerce between states. C. S. Prakash, Our Three Commerce Clauses and the Presumption of Intrasentence Uniformity, 2003. Rather, the evidence points in the opposite direction. Adoptive Couple 2013 Thomas concurring. When discussing commerce with Indian tribes, the founders plainly meant buying and selling goods and transportation for that purpose. For example, President Washington once informed Congress of the need for new channels for the commerce of the Creeks, because their trade is liable to be interrupted by conflicts with England. Statement to the Senate, August 4, 1790, reprinted in 4 American State Papers 80. Henry Knox similarly referred to the profits of this commerce with the Creeks in the context of a trading house which has the monopoly of the trade of the Creeks. Report July 6, 1789. And President Jefferson likewise discussed the commerce that shall be carried on liberally at trading houses with Indians. Statement to Congress, January 18, 1803. All of this makes sense, given that the founders both wanted to facilitate trade with Indians and rejected a facially broader Indian affairs power in favor of a narrower power over commerce with the Indian tribes. As noted above, that omission was not accidental. The Articles of Confederation had contained that Indian affairs language, and that language was twice proposed and rejected at the Constitutional Convention. See Adoptive Couple 2013. Then, as today, affairs was a broader term than commerce, with affairs more generally referring to things to be done. Thus, whatever the precise contours of a freestanding Indian Affairs Clause might have been, the founders' specific rejection of such power shows that there is no basis to stretch the Commerce Clause beyond its normal limits. Thomas Dissent, Section 3A3. Third, the structural principles that the majority points to are only the foreign affairs powers that the Constitution provides more generally. See Lara 2004, citing Curtis Wright 1936. As detailed above, the Constitution plainly confers foreign affairs powers on the federal government to regulate passports, offenses against the laws of nations, and citizens' acts abroad that threaten the nation's peace. S. Prakash and M. Ramsey, The Executive Power Over Foreign Affairs, 2001. Those powers were brought to bear on Indian tribes, with whom the federal government maintained a government-to-government relationship. See example given, Cohen Section 1.031, at 25-26, 1 Statute 470, passports on Indian lands, crimes on Indian lands, enlisting with foreign states. But that authority is a foreign, not domestic, affairs power. It comprehends external relations, like matters of war, peace, and diplomacy, not internal affairs like adoption proceedings. The court made that point explicit in Curtis Wright. The power over external affairs is in origin and essential character different from that over internal affairs. Curtis Wright 1936. See also Youngstone Sheet and Tube Co. v. Sawyer 1952, Jackson concurring in judgment and opinion of court, recognizing this distinction. For external affairs, the Constitution grants the federal government a wider authority, but for internal affairs, the Constitution provides fewer, more discrete powers. See example given, Curtis Wright 1936, Zivotofsky v. Carey 2015 opinion of Thomas. Again, all those limits dovetail with the historical practices of the founding era. As discussed above, the founding era government undertook a wide array of measures with respect to Indian tribes. But apart from measures dealing with commerce, most if not all of the federal government's actions toward Indians either treated them as sovereign entities or regulated citizens on Indian lands who might threaten to breach treaties with Indians or otherwise disrupt the peace. For example, early treaties that dealt with questions of peace and war plainly involved some sort of sovereign-to-sovereign relationship. See example given, Treaty with the Cherokees, 1791, 7 Statute 39. And the early Trade and Intercourse Acts regulated only the criminal conduct of U.S. citizens on Indian lands. This congruence between the government's actions and the Constitution's enumerated powers likely reflects the fact that those powers, collectively, responded to the most pressing concerns of the day. That Congress could not enforce its treaties with Indians, police the frontier, or regulate unscrupulous traders, all of which caused violence and raised the specter of war with Indian tribes. As noted, when Congress tried to expand its domain in 1817 to regulate the criminal acts of Indians, one justice of this court found it to be a palpable violation of Congress-limited powers. See Bailey 1883. And all the while, states continued to regulate matters relating to Indians within their territorial limits. The normal federalist dynamic thus extended to the domain of Indian affairs. The federal government was supreme with respect to its enumerated powers, but states retained all residual police powers within their territorial borders. See Bailey 1883, McCulloch 1819. And the federal government's enumerated powers were not unlimited, but confined to their plain meaning and limits. Thomas Dissent, Section 3b. So where did the idea of a plenary power over Indian affairs come from? As it turns out, little more than ipse dixit. The story begins with loose dicta from Cherokee Nation v. Georgia 1831. In that case, the Cherokee Nation petitioned this court for an injunction to prevent Georgia from enforcing state laws in Cherokee territory and from seizing Cherokee lands. The tribe asserted that Article 3 both allowed the suit and gave this court original jurisdiction because the suit was won by a foreign state against the state of Georgia. Writing for the court, Chief Justice Marshall admitted that the tribe's argument was imposing. The tribe was a state, as a distinct political society, but it was not a state of the Union. Nonetheless, the court refused to hear the case. As Marshall reasoned, Indian tribes were not foreign states in the sense of the Constitution, as shown in part by the Commerce Clause's delineation of states, foreign nations, and Indian tribes. Rather, Marshall reasoned that the Indian tribes occupied a unique status, which he characterized as that of domestic dependent nations whose relation to the United States resembles that of a ward to his guardian. Other than this opinion, I have been unable to locate any evidence that the founders thought of the federal government as having a generalized guardianship-type relationship with the Indian tribes, much less one conferring any congressional power over Indian affairs. To the contrary, such a status seems difficult to square with the relationship between the federal government and tribes, which at times involved warfare, not trust. See example given, Fletcher and Singal. F. Hutchins, Tribes and the American Constitution 2000. And if such a general relationship existed, there would seem to be little need for the federal government to have ratified specific treaties with tribes calling for federal protection. Example given, Treaty with the Kaskaskia 1803, 7 Statute 78, Treaty with the Creeks 1790. At bottom, Cherokee Nation's loose dicta cannot support a broader power over Indian affairs. Nevertheless, Cherokee Nation's suggestion was picked up decades later in United States v. Kagama, 1886, the first case to actually apply a broader, unenumerated power over Indian affairs. In Kagama, the court considered the Major Crimes Act of 1885, which, similar to the 1817 Act held unconstitutional by Justice McLean, while riding circuit, regulated crimes on Indian lands committed by Indians. The Major Crimes Act differed from the 1817 Act only in that it extended to crimes committed against other Indians. See Section 9, 23 Statute 385. Similarly to Justice McLean's Bailey opinion, the court first rejected the idea that the Commerce Clause could support the Act, reasoning that it would be a very strained construction of the clause, that a system of criminal laws for Indians was authorized by the grant of power to regulate commerce with the Indian tribes. Kagama, 1886. But the court determined that the Major Crimes Act was constitutional nevertheless. As the court first noted, the act was confined to the acts of an Indian of some tribe, of a criminal character, committed within the limits of the reservation. The court then cited several cases arising from congressional regulations of Indian lands located within federal territories, noting that Congress had previously punished offenses committed on such lands. Kagama 1886 citing United States v. Rogers 1846, Murphy v. Ramsey 1885, American Insurance Co. v. 356 bales of cotton 1828. Next, the court reasoned that the act does not interfere with the process of the state courts within the reservation, nor with the operation of state laws upon white people found there. Instead, the act's effects are confined to the acts of an Indian of some tribe, of a criminal character, committed within the limits of the reservation. That sort of language seems to view Indian lands as akin to quasi-federal lands, or perhaps external to the nation's normal affairs. But nothing the court cited actually supported such a view. For example, the fact that the federal government could regulate Indians on federal territories does not justify such regulations for Indians within a state's limits. Nor does the fact that tribes were external at the founding mean that they remained external in 1886. Nor does the fact that Congress could regulate citizens who went onto Indian lands, see Rogers, mean that Congress automatically has the power to regulate Indians on those lands. But the court then subtly shifted its approach. Drawing on Cherokee Nation, the court next asserted that Indian tribes are the wards of the nation. Kagama 1886. Because of their very weakness and helplessness, it reasoned, so largely due to the course of dealing of the federal government with them and the treaties in which it has been promised, there arises the duty of protection, and with it the power. This power over the remnants of the Indian tribes, the court stated, must exist in the federal government, because it never has existed anywhere else, because it has never been denied, and because it alone can enforce its laws on all the tribes. These pronouncements, however, were pure ipse dixit. The court pointed to nothing in the text of the Constitution or its original understanding to support them, nor did the court give any other real support for those conclusions. Instead, it cited 3 cases, all of which held only that states were restricted in certain ways from governing Indians on Indian lands. Kagama 1886, citing Worcester v. Georgia 1832, Fellows v. Blacksmith 1856, only the federal government, not private parties, can enforce removal treaties. The Kansas Indians 1867 states cannot tax Indian lands. It does not follow from those cases that the federal government has any additional authority with regard to Indians, much less a sweeping, unbounded authority over all matters relating to Indians. Compare Worcester 1832, suggesting that tribes had long been left to regulate their internal affairs. At each step, Kagama thus lacked any constitutional basis. Nonetheless, in the years after Kagama, this court started referring to a plenary power or plenary authority that Congress possessed over Indian tribes, as well as a trust relationship with the Indians. See example given, Stevens v. Cherokee Nation 1899, Lone Wolf v. Hitchcock 1903, Winton v. Amos 1921. And in the decades since, this court has increasingly gestured to such a plenary power, usually in the context of regulating a tribal government or tribal lands, while conspicuously failing to ground the power in any constitutional text, and cautioning that the power is not absolute. See example given, noting this problem. United States v. Alcia Band of Tillamook's 1946, opinion of Vincent. Santa Clara Pueblo v. Martinez 1978. The majority's opinion today continues in that vein, only confirming its lack of any constitutional basis. Like so many cases before it, the majority's opinion lurches from one constitutional hook to another, not quite hanging the idea of a plenary power on any of them, while insisting that the plenary power is not absolute. While I empathize with the majority regarding the confusion that Kagama and its progeny have engendered, I cannot reflexively reaffirm a power that remains in search of a constitutional basis. And while the majority points to a few actual constitutional provisions, like the commerce and treaty clauses, those provisions cannot bear the weight that our cases have placed upon them. At bottom, Kagama simply departed from the text and original meaning of the Constitution, which confers only the enumerated powers discussed above. Those powers are not boundless and did not operate differently with respect to Indian tribes at the founding. Instead, they conferred all the authority that the new federal government needed at the time to deal with Indian tribes. When dealing with Indian affairs, as with any other affairs, we should always evaluate whether a law can be justified by the Constitution's enumerated powers, rather than pointing to amorphous powers with no textual or historical basis. Dissent, Section 4. Properly understood, the Constitution's enumerated powers cannot support ICWA. Not one of those powers, as originally understood, comes anywhere close to including the child custody proceedings of U.S. citizens living within the sole jurisdiction of states. Moreover, ICWA has no constitutional basis even under Kagama and later precedents. While those cases have extended the federal government's Indian-related powers beyond the original understanding of the Constitution, this court has never extended them far enough to support ICWA. Rather, virtually all of this court's modern Indian law precedents, upholding laws that regulate tribal lands, tribal governments, and commerce with tribes, can be understood through a core conceptual framework that at least arguably corresponds to founding-era practices. To extend those cases to uphold ICWA thus would require ignoring the context of those precedents, treating their loose plenary power language as talismanic, and transforming that power into the truly unbounded, absolute power that they disclaim. The basic premise that the powers of the federal government are limited and defined should counsel against taking that step. Dissent, Section 4a. ICWA lacks any foothold in the Constitution's original meaning. Most obviously, ICWA has no parallel from the founding era. It regulates the child custody proceedings of U.S. citizens in state courts, not on Indian lands, merely because the children involved happen to be Indians. No law from that time even came close to asserting a general police power over citizens who happen to be Indians, by, for example, regulating the acts of Indians who were also citizens and who lived within the sole jurisdiction of states and not on Indian lands. If nothing else, the dearth of founding-era laws even remotely similar to ICWA should give us pause. Nor can ICWA find any support in the Constitution's enumerated powers as originally understood. I take those powers in turn. First, the Property Clause cannot support ICWA because ICWA is not based on the disposition of federal property and is not limited to federal lands. In fact, the federal government owns very little Indian land. See Statistical Record of Native North Americans 1054 M. Reddy 1993. S. Prakash, Against Tribal Fungibility 2004. Second, the treaty clause cannot support ICWA because no one has identified a treaty that governs child custody proceedings, much less a treaty with each of the 574 federally recognized tribes to which ICWA applies. 25 U.S.C. Sections 1903-3, 8, 86 Federal Regulations 7554-2021. Nor could they. Congress declared an end to treaty-making with Indian tribes in 1871, and it appears that well over half of the tribes lack any treaty with the federal government. See 16 Statute 566, Brief for Tribal Defendants. See also generally Volumes 1-2 C. Kapler, Indian Affairs, Laws and Treaties 1902-1904. And in part because one Congress can never bind a later Congress, the federal government retains the power to abrogate treaties and has done so for at least some Indian treaties. Example given, Lone Wolf 1903, Accord, La Abra Silver Mining Co. v. United States 1899, 1 W. Blackstone, Commentaries on the Laws of England 90 1765 Blackstone. Whatever number of treaties remain in force, they cannot justify ICWA. Third, the Commerce Clause cannot support ICWA. As originally understood, the clause confers a power only over buying and selling, not family law and child custody disputes. Even under our more modern, expansive precedents, the clause is still limited to only economic activity and cannot support the regulation of core domestic matters like family or criminal laws. See Lopez 1995, United States v. Morrison 2000, National Federation of Independent Business v. Sebelius 2012 opinion of Roberts, Scalia, dissenting, and even Kagama itself rejected the Commerce Clause as a basis for any sort of expansive power over Indian affairs. Kagama 1886. Therefore, nothing about that clause supports a law, like ICWA, governing child custody disputes in state courts. Fourth, the federal government's foreign affairs powers cannot support ICWA. For today's purposes, I will assume that some tribes still enjoy the same sort of pre-existing sovereignty and autonomy as tribes at the founding, thereby establishing the sort of quasi-foreign, government-to-government relationship that appears to have defined those powers at the founding. Even so, the foreign affairs powers can operate only externally, in the context of lands under the purview of another sovereign like Indian tribal lands, or in the context of a government-to-government relationship such as matters of diplomacy or peace. See Curtis, Wright 1936. But regulating child custody proceedings of citizens within a state is the paradigmatic domestic situation. The federal government surely could not apply its foreign affairs powers to the domestic family law or criminal matters of any other citizens, merely because they happen to have citizenship or ancestral connections with another nation. Apart from the single provision that allows tribal governments jurisdiction over proceedings for Indians on tribal lands, see Section 1911A, ICWA is completely untethered from any external aspect of our nation that could somehow implicate these powers. That should be the end of the analysis. Again, as the majority notes, our federal government has only the powers that the Constitution enumerates. McCulloch, 1819. Not one of those enumerated powers justifies ICWA. Therefore, it has no basis whatsoever in our constitutional system. Thomas Dissent, Section 4b. Even taking our plenary power precedents as given as the majority seems to do for purposes of these cases, nothing in those precedents supports ICWA. To be sure, this court has repeatedly used loose language concerning a plenary power and trust relationship with Indians, and that language has been taken by some to displace the normal constitutional rules. But even taken to their new limits, the court's precedents have upheld only a variety of laws that either regulate commerce with Indians or deal with Indian tribes and their lands. Despite citing a veritable avalanche of precedents, respondents have failed to identify a single case where this court upheld a federal statute comparable to ICWA. As noted above, Kagama was careful to note that the Major Crimes Act at issue was confined to the acts of an Indian of some tribe, of a criminal character, committed within the limits of the reservation. Kagama 1886. In that vein, the opinion cited cases arising from congressional regulations of Indian lands located within federal territories. Kagama 1886, citing Rogers 1846, citing Murphy 2018, and 356 bales of cotton. In other words, it is possible that Kagama viewed Congress as having the power to regulate crimes by Indians on Indian lands, because those lands remained in a sense external to the nation's normal affairs and akin to quasi-federal lands. Again, that would be a non sequitur. Nevertheless, at a high level, it is possible to see how Kagama was rooted in the same foreign affairs and territorial powers that authorized much of the early trade and intercourse acts, and which Congress may have relied upon when passing the 1817 Act. See Cohen Section 5.014 linking Kagama with Curtis, Wright 1936. United States v. Wheeler 1978, describing Indian tribes as possessing a pre-existing sovereignty, apart from the United States. And viewed in that light, it would make sense to limit Kagama to that conceptual root, treating regulations of tribal lands and tribal governments as external to the normal affairs of the nation. Indeed, such a line explains almost all of the myriad cases that respondents have catalogued as showing an unqualified power over Indian affairs. See example given, Michigan v. Bay Mills Indian Community 2014, Tribal Government Sovereign Immunity. Cherokee Nation v. Hitchcock 1902, Federal Approval of Mining Leases on Tribal Lands. Stevens v. Cherokee Nation 1899, Federal Court in Indian Territory. Many, for example, dealt with federal laws that purported to diminish a tribe's territory or jurisdiction. South Dakota v. Yankton Sioux Tribe 1998, Negonsot v. Samuels 1993, Washington v. Confederated Bands and Tribes of Yakima Nation 1979, United States v. Hellard 1944. Others dealt with state taxes on Indian lands. See example given, Cotton Petroleum Corp. v. New Mexico 1989, Bryan v. Itasca County 1976, Board of County Commissioners v. Seber 1943, Choate v. Trapp 1912. Others still have permitted the federal government to diminish a tribe's self-government. See Santa Clara Pueblo. And yet others in Kagama's direct lineage dealt with crimes on Indian lands. See example given, Lara 2004. See also example given, United States v. Cooley, 2021 slip opinion, Wheeler 1978. In doing so, some of those criminal law cases reason that the Double Jeopardy Clause permits separate punishments by tribal governments and the federal government because of the tribe's separate sovereignty, underscoring Kagama's conceptual root. See example given, Cooley 2021, Lara 2004. And along the way, at least some of these cases clarified, like Kagama, that they dealt not with Indians who have left or never inhabited reservations set aside for their exclusive use, or who do not possess the usual accoutrements of tribal self-government, but only with Indians residing on Indian lands. McClanahan v. Arizona Tax Commission 1973. Accord. Fisher v. District Court of 16th Judicial District of Montana 1976, per curiam dealing with an adoption proceeding in which all parties are members of the tribe and residents of the Northern Cheyenne Indian Reservation. United States v. Algoma Lumber, Co. 1939 Regulations of Contracts for the Sale of Timber on Land of the Klamath Indian Reservation. In case after case, the law at issue purported to reach only tribal governments or tribal lands, no more. To be sure, applying Kagama's conceptual framework ultimately reveals a catch-22 of sorts. If Congress regulates tribal governments as a matter of external affairs, then such regulation seems to undercut the very tribal sovereignty that serves as the basis for that congressional power. See Lara 2004, Thomas concurring in judgment. But that appears to be a hallmark of Kagama and its progeny, not a peculiarity. As Chief Justice Marshall once stated, Indians are neither wholly foreign nor wholly domestic, but are instead domestic-dependent nations, akin to tributary states. Worcester 1832, Cherokee Nation 1831. It may be that this contradiction is simply baked into our Indian jurisprudence. And in any event, recognizing the proper conceptual root for these precedents makes the most sense of them as a textual and original matter, and it is surely preferable to continuing along this meandering and ill-defined path. Yet, even confining Kagama's conceptual error to its roots, the majority seems concerned that other precedents suggest that the Commerce Clause has broader application with respect to Indian affairs. But many of this court's precedents, even when referring to some broader power, dealt with laws that govern trade with Indians, no more. See example given, United States v. Holiday 1866, selling liquor to Indians, Perrin v. United States 1914, United States v. Sandoval 1913, Dick v. United States 1908, selling liquor on Indian lands. Thus, even if those cases suggest a broader power, they must be taken in context, and the cases that the majority cites for its proposition turn out to be the ones that do so in the most obvious dicta. For example, Cotton Petroleum considered state taxes on Indian lands. It had no need to opine on the Commerce Clause, beyond explaining that Indian tribes are not states. See Cotton Petroleum Corp. v. New Mexico, 1989. In a similar vein, Seminole Tribe of Florida v. Florida, 1996, held only that the Commerce Clause does not confer any authority to abrogate state sovereign immunity. Any language about the breadth of the Indian Commerce Clause was wholly unnecessary to that result. Shorn of their dicta, all of these precedents reflect only the long-standing and enumerated authority to regulate commerce with Indian tribes. Other precedents cited by the majority that do not fit into Kagama's conceptual framework are easily explicable as supported by other specific powers of Congress. For example, Lone Wolf held that Congress can enact laws that violate treaties with Indians. That holding was justified by Congress' general power to abrogate an existing law or treaty. Lone Wolf 1903, Accord, La Abra Silver Mining Co. 1899, Blackstone 90. Another treaty-based case, Delaware Tribal Business Community v. 1977, involved the disposition of funds paid pursuant to a treaty. It therefore makes sense as a matter of both the property and treaty clauses. And yet another treaty-based case involved a promise by the United States to establish a discrete trust fund with $500,000 for a tribe, with annual interest to be paid to the tribe. See Seminole Nation v. United States 1942. Though that case spoke of historic trust obligations, it arose from an explicit promise to create a trust with $500,000 and 16 cents. There is little reason to view such cases as expanding Congress powers. Accordingly, the context of all these cases points to lines that are at least plausibly rooted in founding-era practices and the text of the Constitution. See Brown v. Davenport 2022. Slip opinion. Judicial opinions must be taken in context, not read like statutes. Congress can regulate commerce with Indian tribes. It may be able to regulate tribal governments and lands in Kagama's vein, and it can make treaties, dispose of federal funds, and establish discrete trusts. ICWA does not remotely resemble those practices. It does not regulate commerce, tribal governments, or tribal lands. Nor is it based on treaties, federal funds, or any discrete trust. By regulating family law matters of citizens living within the sole jurisdiction of states merely because they happen to be Indians, ICWA stands clearly outside the framework of our Indian law precedents. To uphold ICWA, therefore, would drastically expand the context in which we have previously upheld Indian-related laws in Kagama's framework. But even if that is so, the majority appears to ask why Congress's power is limited to these scenarios. The majority nearly answers itself. Because our Constitution is one of enumerated powers, and limiting Congress authority to those buckets would bring our jurisprudence closer to the powers enumerated by the text and original meaning of the Constitution. While I share the majority's frustration with petitioners' limited engagement with the court's precedents, I would recognize the context of those cases and limit the so-called plenary power to those contexts. Such limits would at least start us on the road back to the Constitution's original meaning in the area of Indian law. The Constitution confers enumerated powers on the federal government. Not one of them supports ICWA, nor does precedent. To the contrary, this court has never upheld a federal statute that regulates the non-commercial activities of a U.S. citizen residing on lands under the sole jurisdiction of states merely because he happens to be an Indian. But that is exactly what ICWA does. It regulates child custody proceedings brought in state courts for those who need never have set foot on Indian lands. It is not about tribal lands or tribal governments, commerce, treaties, or federal property. It therefore fails equally under the court's precedents as it fails under the plain text and original meaning of the Constitution. If there is one saving grace to today's decision, it is that the majority holds only that Texas has failed to demonstrate that ICWA is unconstitutional. It declines to disturb the Fifth Circuit's conclusion that ICWA is consistent with Article I, but without deciding that ICWA is, in fact, consistent with Article 1. But given ICWA's patent intrusion into the normal domain of state government and clear departure from the federal government's enumerated powers, I would hold that Congress lacked any authority to enact ICWA. I respectfully dissent.